It's live.
Good evening, everybody. This is the meeting for the Cleveland Community Police Commission Rules Committee. It's Monday, March 27th, and we are at Perkins Avenue, our location, and we welcome the public's input on this meeting. The meeting is starting at 5:08 p.m. I'm going to do a roll call. Commissioner Benicio. Present. Commissioner Donaldson.
Present.
Commissioner Ridgway. Present. Commissioner Rodriguez.
Present.
And I'm Commissioner Wong. So thank you so much to everybody that is joining us online and in person. So the agenda for today is that we will continue our discussion of the previous draft administrative procedures, specifically the formation of the Brady Giglio list that is under Charter 115. We have a few guest speakers that have graciously given their time today. Karrie Howard from the Director of Public Safety is the Director of Public Safety for the City of Cleveland, and Kristen Sobieski is with the Appeals Unit Supervisor and Public Policy Director with the Cuyahoga County Prosecutor's Office. So we welcome them. And we can move on to, what do you think, Jason? Should we maybe we can give a brief overview of what Brady Giglio list is supposed to do for our community members listening in that didn't get a chance last time.
And I think our guest, particularly from the prosecutor's office, can kind of maybe give a brief overview of what it is before you explain what you do with it, right? Would that be? Yeah. Okay. All right. So why don't we let Kristen come up and go ahead and since she brought her time in tonight, take it away.
So you are being broadcast.
Okay.
So,
can I have a seat over here? Or
so yeah, you can sit or you can stand up here, sit across from me here. Oh, you can stand up. Yeah, sit up wherever you're comfortable.
Okay.
But we have to use the mic so that it can be picked up to broadcast.
Okay, understood. Thanks for having me. Kristen Sobieski. I'm with the Cuyahoga County Prosecutor's Office. I am on the Giglio committee in our office, and I have been on that committee since its inception under Prosecutor O'Malley. Prosecutor O'Malley is sought about
When was that?
2017, sort of more formalizing our process of tracking potential impeachment material, because it's a responsibility that we have for all of our witnesses in every trial that we put on, not just law enforcement witnesses. But the work of the Giglio committee now is we deal a lot with the law enforcement community, and what we do is every year, the office, we send out a letter to every single police chief in Cuyahoga County, and what we ask for is for them to please provide us with any information that we might, as the state of Ohio, be required to disclose to the defense in a criminal prosecution. So it's all about what kind of evidence might be helpful to a defendant that the state has in its possession, and our obligation to then turn that over. And so there's a couple of, big cases, and which I can talk about a little bit. I just want to be clear that, my presentation here tonight, I'm just sharing with you what we on our committee do in the office, but I can't act as legal counsel, of course, for you folks. So it's none of this is legal advice. I can just tell you a little bit about what we do and how we do it. So the cases, that all of this comes from, Brady and Giglio, those are two, and Bagley is another big one. These are major cases from the Supreme Court of the United States. And, I would just start out by noting actually none of those cases involve police misconduct. So these are the cases that we are interpreting, and we're applying the standard that is the burden that is on the state of Ohio in turning over exculpatory evidence, impeachment evidence. We're taking it from these cases, but really none of those cases actually involve police misconduct. So I think that's just an important starting point. But those kinds of cases, for example, the situation in one, for example, was the state of Maryland in the Brady case did not turn over to the defense a statement that a co-defendant made. The co-defendant had made multiple conflicting statements, provided multiple conflicting statements out of court. Some, but not all, were turned over to the defense. And so how that case ended up getting reversed was because, hey, the state of Maryland, you did not turn over this one statement where the co-defendant admitted to doing the killing. And that was critical. So that should have come out at trial, should have been fleshed out in front of the jury. So you can see, so that would be exculpatory evidence. We've got to make sure that the state is prepared to turn over all exculpatory evidence. From that evolved this idea of impeachment evidence. So when you have information that a defense attorney might use to challenge the credibility of somebody who's testifying, that's impeachment evidence. So now what that came out in a case, for example, where the DEA agents had actually paid witnesses for their testimony. And which is, you know, at the time it was something that was done and it was not disclosed. So if it had come out at trial, that would be one thing, it would all be fleshed out. People can take that into account. The jurors could take it into account when weighing their credibility. But because it had not been disclosed, that was a case that had to be reversed for a new trial. So those are the kinds of things that it's incumbent upon the state to disclose. It's information that is only held by the state, like the defense doesn't know, can't know it exists necessarily. Information that is readily available in the public realm, that's outside of what we're talking about here. We're talking about what do we as prosecutors, what information do we have possession of that a defendant may need access to make sure his or her right to due process is not violated. So as applied to law enforcement, how we handle it, as I said, every single year we send to every single chief in this county a letter saying, this is what our obligations are. If you have any information related to any of your officers that we need to be aware of and we need to disclose in our cases, you know, please send that over. So that's one of the ways that we get information referred to our committee. Yes.
So one thing that I was curious about is, so the burden is on the state to disclose that information if you have it.
Correct.
Then if you put out these annual calls to all the police chiefs in the county to say, can you please provide me with this information or provide us with this information? If they do not provide that information, is the state absolved of any responsibility then?
No, and that's exactly why we take this so seriously, because it is incumbent. So another one of the cases that we use as the touchstone, it was actually the Giglio case. In that case, again, it was an issue with a co-defendant, and a deal was made by a prosecutor with that co-defendant saying, hey, if you testify truthfully against the other person, you know, you'll get a deal. Now it was a separate prosecutor who was trying the one on trial. The trial prosecutor had no idea that promise had been made, that arrangement had been made. And so when they're trying the case and the witness is asked, were any threats or promises made to you? And the witness says no, that mistake was never corrected by the trial prosecutor. They had no idea that the plea agreement existed. So that's the kind of thing. And so the case was reversed for a new trial because it was incumbent upon that trial prosecutor to know. Even if the police department has information and we've asked for it, but they didn't give it to us, it can still reverse a case on us. Right. Mm-hmm. So that's one of the primary ways that we solicit the information is our annual letter, but also there's other ways that information comes to us. I know you're particularly interested in Cleveland, so I can tell you that we have there are divisional notices, which I'm not sure if you're familiar with what those are, but officers who are being disciplined for different things, those come directly to the committee. So the committee meets. We look at any officers who may have had a discipline problem. We make a decision and a recommendation about whether we think that particular issue amounts to something that this officer could be impeached with if they were to testify at a trial. We make a recommendation to Prosecutor O'Malley, and he makes a decision either, yes, he agrees that this information is potential impeachment material, or no, he doesn't. And if he does agree that it is, then what we do is we don't actually have a list. We don't keep like a list per se. What we do is we have a case management system that allows us, all of our officers basically it's like an address card, and we can attach to that address card information that's critical, that's related to that officer. So that way we know for certain that it's getting into the electronic files of every case that officer is attached to. So we'll make a note and add some information onto the card. So we know that our prosecutors who are working with that officer will have the information and can make a disclosure during the discovery process.
Are there any questions?
So, do both the responses to the annual request by the prosecutors and the divisional notices, do they both go in front of the committee and then the committee makes a recommendation to Prosecutor O'Malley? Is that the process for both?
Yes.
Okay.
Yes. So, and all of the information flows through the committee, whether it comes from an APA who had an issue come up in a trial, whether it comes through, the divisional notices that are sent from Cleveland Police Department to us, whether it's in response to our annual letter. There's all different avenues. It's not just a real linear process. There's all different ways in which information could come to the committee, and then we will take a look at it. And, if we have enough to make a recommendation on, we go ahead and do that. If we need to do some more digging ourselves, we do that. And then, ultimately the officers say, if we are going to flag them with some potential impeachment material, that's when we would send a letter to the chief and to that officer saying, this is what we've identified.
Anybody else? So I had a question. If, I'm assuming, is the officer notified when he or she has gone through this process that they are considered an impeachable witness?
Right. We send the letters, technically it's addressed to the chief, but with direction to please communicate with your officer that this is.
And do they have a way to, is that a final recommendation? Is there?
There can be, and there have been times where we initially identified some information that we thought was potential impeachment material, and then we had to revisit that and reverse course and retract an initial letter that we may have sent out. So it can be very fluid, and we just are working with the information we have in the moment. If we think it's something we need to start disclosing, we will do that. If because of circumstances and things develop down the road. I'll just, for example, say it's a criminal case, say an officer picks up a criminal case themselves, and maybe there's a felony charge there, and we're concerned about that, and they're going to be testifying in a case tomorrow, and we want to go ahead and make sure we make that disclosure in case that is going to be, relevant evidence in that trial. Maybe it won't be, but we want to at least make the disclosure. But then say the officer goes to trial themselves and they're acquitted. Well, now we're going to have a completely different mindset. If their acquittal is an acquittal, and we're not going to be making any disclosure about the fact that they were ever indicted. So there's, there can be some back and forth, and it's. Sorry.
So in the case management system, is there a way to filter out the impeachment material? Like, I'm just trying to figure out if there's a way for you to kind of see who has that material attached to their file.
I don't think that there is. I'm not information services type, but I don't think that there's a way to just pull that out. And I don't know whether for certain, but I know we've had some public records requests made, and I don't know that you can just say, here's all the officers or here's all the material. It's just not managed that way in the system. Mm-hmm.
Have there been any problems, even just scenarios that in getting that information from the police, Department of Police, that you, that you find out after the fact that you should have impeached a witness and this wasn't given in a timely manner? Or
I would say that and again, I'm speaking broadly over the county, that they're very receptive to providing us with the information that we ask for. And there are long processes, especially when you're talking about law enforcement and maybe discipline that's issued, and there's, an arbitration that might, and it reverses things. And so I don't feel that we have a problem with that at all, really. We make the requests and we have information flowing into us. So it's not.
Is a defense attorney able to, how would they wait for you to get your officer?
So the best way for them to get it is in discovery in the actual trial. So they're requesting from the state of Ohio, all of the evidence, both, inculpatory and exculpatory in the case. And that's when our office pushes it out through our portal notification that, an officer had been flagged for one reason or another. Mm-hmm.
I know you said you don't keep it kind of like a formal list, but do you have any kind of idea of how many different maybe officers have that attached to their case management file on your system?
I actually don't have a number.
Okay.
We've reviewed a lot over the last, 5 or 6 years.
Do you have like a maybe just which I think I'm just trying to get a general idea of scope. Maybe how many are added, like how many get reviewed a year or a month, or how often does the committee meet actually?
At least monthly. Sometimes it's a couple times a month.
Okay.
We, we have a regular meeting, but then there's always stuff that's, we might have like a little bit of a lead about something, and this person is also involved in a trial that's coming up. So then we might, take action quickly to try to, make sure that we're covered there. But we do have sort of a standing meeting where we, go over different inquiries as they're made of the committee and things like that.
So do you think it's like 10 a meeting or less than that? I know.
Yeah, it's just like an ebb and flow. Sometimes it's quite a lot, and sometimes it's hardly any at all. So yeah.
Okay, cool.
Yeah.
Thank you.
Commissioner Van Leer has a question.
Thanks. Hi, I'm a commissioner, but I'm not on this committee. I'm just
Hi,
watching.
nice to meet
So, for clarity, this work that you're doing started in 2017. So before that, there is really even less real tracking or work on this, or is
I
that?
can't really speak to exactly what the prior. I came back to the office when Prosecutor O'Malley was elected in 2017, and so I've been involved with the committee that he started. It wasn't a very formalized process at that time, but that question is kind of more for the people who were working with the office then.
Okay, and it sounds like, so one of our roles that's written in section 115 is to track this and to get this information. So it sounds like it's not very easily trackable from your office. I mean, I know you can't give us like a decision of like how it would work, but like how would you just said before, there's no filter, you can't just search.
Right.
But
Right.
we do, there's one of our roles that's written in the law to say that we need to track this and gather the information. So I'm wondering how that might happen.
It's a very good question. That's a very good question. It's a big complex issue, for our office, trying to suss out and manage this information, across the county.
Of course, we're focused on Cleveland. So, I mean,
Right.
at the very least, letters that you send out, I guess, would be one. I mean, we would get copies of those letters. Do you have a file with copies of all those
Yes,
letters?
whether the department would,
Surprise.
I don't know if the department would share with you, letters that have been sent over by my office. That's, again, I don't know.
All right, thank you.
Yes, of course.
Any other questions?
I do.
Okay, Mr. Donaldson.
So when the police chiefs are sent the letters annually requesting information, is it more of a broad request, or does it kind of lay out what type of information they should be sending in?
I don't have a copy of the letter with me, but I think it does it cites the cases, says, any information that might go to a bias or a problem with untruthfulness. I think there might be a couple examples like
Okay.
that. And then actually, sometimes they'll call up and say, I have a situation, I'm not sure if it falls within what you're asking. And usually what we say is, if you're not sure, send it down to us and let the committee take a look at it.
Okay, and then is that letter based off of some sort of template?
Yes, the annual letter.
Mhm.
Yes.
Okay, is it possible for us to see the template?
Let me check with my office in that, but I can certainly look into it
All
now.
right, thank you.
Could you, before we move on to could you maybe go into a deeper dive with the type of discipline that would qualify? You mentioned bias and untruthfulness.
Right.
But just so we understand. And maybe I'm misunderstanding. Is it so they have to volunteer, the police department has to volunteer this information. Are you guys basically on the same page of what would qualify? It's not every discipline that the
It's not
officer
every,
may
no.
receive would qualify.
Correct. No, and we don't have to wait for discipline to be issued for us to independently determine that we think there's a problem there and we need to flag. flag an officer. So it isn't dependent on, they must be disciplined for X, Y, or Z, and then the committee will do its thing. We will do, if we have the information ourselves, we will make our own determinations. Sometimes it is the fact that they have been issued discipline for some sort of conduct. But it is things like we are looking for, because this is all about their credibility on the stand. So, so it's things that may show a bias or an animosity toward a certain or a problem with untruthfulness. But even that can get, honestly, it can get very tricky. It's lots of whether somebody writes something in a report and one person may say, well, that was untruthful, but it could be an accident. It could be, maybe it's just
Difference in perspective.
right. Exactly. So it's not, it isn't cut and dried. I can tell you that for certain.
So I will get to, I just want to continue. So when the information is not coming from this police discipline, what would instigate your office to even look into an officer? Is it because there's a pending case that you want to make sure that these officers are to be admitted as witnesses, or?
The information can come from all different sources. It could come up in the context of a different prosecution that there's an issue arises with respect to testimony from a certain officer that we maybe would have to look at that. Sometimes, and again, once it's in the public realm, it's sort of outside of what we really need to be the most worried about. But sometimes it is in the public realm. We'll see, an officer was charged with some offense themselves or accused of, something like that. Sometimes that's how we initially we got to, take a look at that one. So information comes to us from all different directions.
So to go back, I guess I'm still, you said the result is you don't want someone that's biased and has all these
Correct.
things, but what, if you can characterize it in terms of the language, nomenclature of police discipline, what would that look like?
It's, there's
It's not just bias against a victim, it's bias,
Mhm.
right?
Mhm.
It's a broader sense of bias, right?
Yeah, so we see all kinds of discipline that comes in, but one that would jump out at me is if the discipline was actually issued for finding of untruthfulness, that was something I would want to take a look at right away.
Any questions?
You go first.
Okay, so you send this to the chair. You send this letter out
Mhm.
once a year.
Yes.
And once you get the results back, do you automatically send it to commissions like ours, or do we have to request it?
Right. No, yes, our function, what I'm most concerned with is prosecuting cases.
Mhm.
So our office is looking at making sure that the due process rights of the defendants that we are prosecuting are not violated. And so that's my purpose in looking at any of this stuff, is I want to make sure that to the extent that any witness that we are putting on the stand could have their credibility challenged, I want to make sure that we've shared that information with the defense. So no, I would not say that it's part of our obligation necessarily to provide, other than to notify the chief that the officer works for, that we feel that we will be making this disclosure in cases that we are prosecuting where this officer is testifying. That's what our focus is.
So part of what you're doing, actually, your office will be tracking these cases that might be coming up where officers might
Mhm.
be either testifying.
Yes,
Okay, and it goes from there.
right.
All right, thank you.
Right.
Ms. Benito?
Thank you I know we have a lot of questions, so I
It's
really
okay.
appreciate it. A couple questions. One is, in the information that is sent to, the opposing counsel as part of the, discovery, how much information is given about why the, officer or any other witness or, co-defendant, how much information is put in there? Is it just kind of like, hey, heads up, this person is on this list, or is it,
It depends what we have.
Okay.
Yeah, it depends what we have. You know, sometimes if it is a letter where discipline has been issued and based on a finding of untruthfulness, maybe we just take that letter and attach it to the officer's, address card. And so they will have an actual document to disclose. Sometimes it could just be a note in the file that we know XYZ happened and they should disclose that. And so we're very focused on what is our obligation on behalf of the people of the state of Ohio to be disclosing. And so if I need to find out where these things exist, I need to disclose that they are out there, but I don't necessarily have to go track down, a complete investigation that was done about it and disclose that in the context of every criminal prosecution. I just need to disclose that I know that there's something out there. Defense counsel, if you would, want to pursue that on your own, go for it. But we do not have to have, and we may not necessarily have.
And then, go ahead. And then the other question that I had is, I lost that one, but I had a third one, so I'll just go to the third one. Is any of that information considered, the third question is, I'm gonna ask Jason a question, but is any of that, is there any requirement of that kind of information being shared prior to the process of discovery? So one thing I'm imagining is for folks who might be considering plea deals, I know that there's no discovery prior to it.
No, there is.
Oh, there is.
Oh,
would
absolutely.
Would it be part of the discovery for this before the decision of a plea?
It depends.
Okay.
It depends because, what it really hinges on is that officer, because you may have an officer who has been flagged with potential impeachment material that was tangentially related to an investigation, and the state can make its case without calling them to testify. Well, this is information that is only maybe relevant if the officer is testifying. So, so it goes out in discovery, but it depends on exactly.
Okay, and then my question for Jason is, according to section 115, I know that we're tasked with, creating this list and also making that list public. Does it say anything about what information has to be attached to that, or is that something that would be considered for our rules procedure, just in terms of obviously you wouldn't need to know names of officers, like the fact that they are on a list, but then that reasoning, does the law give any direction upon how much information is needed?
To the chair, not to the commissioner, to the chair, not off the top of my head do I recall any specifics. It's more abstract about identifying and creating a list of officers who qualify or potentially qualify, that's not the exact wording, but we have a different standard even than what they have, that we have some discretion to look at, Cleveland things specifically and say, well, the prosecutor didn't think so, but this commission thinks so. So that's the other area that we have to explore because it's new for everybody. And I don't think there is a mandate anywhere else in the country where another body or commission besides the prosecutor's office is getting involved legally in this process. So this is a new ground for this area specifically and maybe the nation.
Thank you. Okay, so I had a series of questions, because you mentioned before exculpatory evidence and impeachment evidence. So my understanding is that exculpatory is, it would absolve the person, and impeachment is specifically for removing these witnesses. So Brady violations, my understanding, go beyond just impeachment of witnesses, right? There could be Brady violations about exculpatory evidence that wasn't given. Could you give us some examples of, evidence that wasn't given during?
Well, okay, so like in the Brady case itself, I can tell you. So in Brady versus Maryland, the exculpatory evidence that was not turned over was the co-defendant Boblet, who made all of these extrajudicial statements that were conflicting in nature, one of which he took responsibility for the actual murder himself, and that particular one did not get turned over in discovery. So that was called exculpatory evidence. So that would mean it would tend to negate one of the elements of the offense that the state is required to prove.
Right, so this is just
So-
a point that I hope you're making, is that it's not like we're just maintaining a list of police officers, right? The Brady violation, or the Brady kind of upholding Brady it's not just about impeaching officers, it's about, what is the requirement for 115?
I'll pull it up.
Because say, there was evidence that could help the defense and it wasn't provided, how is that, that information given to the public?
My understanding is that we're being tasked with creating a list of law enforcement officers, not all information that would be covered under Brady, where they have been flagged as potentially having things in their background that would, and it sounds like most of what we're talking about is going to be under impeachment
Mhm.
in like evidence or information. I imagine that there could be exculpatory if there was like a problem with the investigation.
Right, so when we're talking about like the work of the Giglio committee, we're really talking about identifying potential impeachment evidence. And the impeachment concept just comes from that exculpatory concept, like it flows from that if you don't turn over impeachment stuff, that can have the same effect, essentially, of violating due process.
So I guess my question
Do you want
is.
the exact word?
in 115.
Maintaining and generally updating information on individual police officers whose career records or personal history merit designation or disclosure, even reasonably arguably advisable under Brady versus United States or Giglio versus United States, in those cases progeny. So it goes on, but it does appear that it's about individual police officers whose records indicate or personal history merit designation or disclosure. So,
Right. So, and it sounds a little bit different than what our real focus is too, because we're talking about, what could be potentially be used to impeach a witness. And when we flag these officers, for us, it's lay witnesses, expert witnesses, and also law enforcement officers. But when we flag an individual with potential impeachment material, that's not a statement by the state of Ohio that is relevant or admissible evidence. Those are entirely different, again, legal, standards and calculations. It's just, we are to err on the side of disclosure. So we try to suss out the information, at least disclose it to the defense. And then, we end up filing motions and litigating whether it's actually evidence that gets in front of the jury or not.
But I'm sorry to double back on it, but any Brady violation, is there a record of that kept through your office
No.
beyond just impeachment of officers? Just any exculpatory, is there
If a Brady violation happens in a criminal prosecution, is there a separate record kept of that? No, not to my knowledge.
and do you go through at the appellate level, do you try to find, do you go through the case, or are any other Brady violations there? Does your committee?
No, would I look backwards at old appellate cases to try to find out if there was an officer who had, no.
Or any Brady,
Right.
Because the Brady violation goes beyond than just like the officer, right? Just impeachment of the officer. And I guess they're kind of overlapping in some ways.
Very much, yes,
Right?
yeah.
Okay. Anyway,
To the chair. Oh,
okay, do you want Ms. Vickers have to go first?
No, she go first.
Okay.
I just got some questions for her.
to the chair. The reason we invited you here in part, there was a statement here, and I had brought this up. It says that we are responsible, that the citizens of Cleveland have charged the commission with managing a list of Cleveland Division of Police officers who may qualify due to past history or behavior. And so my question was, what does managing mean? Does that mean we have to maintain a list? I didn't understand what managing meant. And so we thought it would be good to invite you to help us understand what our responsibility is to the
So-
citizens of Cleveland under this mandate.
And that's where I want to be especially clear.
Okay.
Everything that I'm sharing with you, this is sort of like on background. This is how the Cuyahoga County Prosecutor's Office manages our obligations under, Brady versus Maryland and Giglio, so as far as legal counsel to you, for how you should set about doing what you are, which you are tasked with, that would be, for your attorney, whoever is acting as your counsel, to answer those questions for you.
And to the
So
chair,
she's giving us the process that they use.
that they use,
And
right?
now understanding that, then we ought to be able to take their process and see how do we integrate that into what our responsibilities are.
And to the chair, to the commissioner, I think management is a summary of what it says here: soliciting, gathering, compiling, organizing, maintaining, and generally updating information. So all of those things fit into that summary of managing, right? So that's a lot of work just there: soliciting, gathering, compiling, organizing, maintaining, and generally updating information. That's just one component of it. And then it does say that it has to be publicized. So when we do that, the next step would be publication of that work of managing all those components
And
there.
that
So,
goes back to the question I asked earlier in terms of how do we get that information?
right. And this is
In
one
order for
point.
us to do all of those things, how do we get the information that's
And
compiled?
this is someone who's already doing the work, so they would be considered one source of information, right, in a sea of it. So we also have the division, we have the city prosecutor's office, right? We have our own knowledge, which we gather. We have the disciplinary letters. We have public information, right? So we may see things or hear things that are out there in the free space on social media or whatever, right? So there's all kinds of sources of information we gather from, but these are the only people currently working this problem on a monthly basis, right? So it's a starting point in that soliciting, gathering, and compiling, right? So that we can get the letters that they create, and that gives us one source of something to start with that we don't have to put work into, especially if Prosecutor O'Malley has already said, we think this person qualifies, right? So that's an instant win for us to say, okay, well, at least at the very least, we could put that public facing because the information is out there and it's common knowledge, and we're the only entity charged. They're not charged with making it public facing. So their task is integrity of the court case, right? And that due process, as she mentioned. We're charged with public concern. So the reason we've been given this is because knowledge of the world, people now know this exists, and it's a matter of public concern. They want us to be the avenue for showing what's going on, the window into this world and other sources of information. So that's kind of my summary of that.
Thank you.
Oh, well, I'm just gonna say, I just be so glad when you guys get an attorney to interpret this stuff, because it is critical. Nothing personal against you, ma'am, but I deal with your office quite often. I'm a private investigator, and a lot of that stuff that you're telling them, I totally disagree with. I'm very aware of the Brady list, not the Brady list, but it's called a blacklist. And the blacklist was around before 2017. I was wrongfully indicted by a dirty cop named Vincent Lucarelli. And what happened was, I was out working on a case. It was the state of Ohio versus Anthony Thomas. I was out working on a case. It was a domestic violence case. He contacted me and told me to stop talking to his client. I'm thinking we're talking about a lawyer here. So next thing I know, I'm indicted. So the lawyers that I'm working for and all these other lawyers like, how did you get indicted just going out doing your job? And I record because on the 2933.52, I can record you without your knowledge. So what we did was we pulled my phone records, pulled his phone records, and found out he was sleeping with victims of cases he was investigating. So what he was doing, if it was a domestic violence victim, and this is true, this is not a lie, this is true. Domestic violence victims, he would advocate as he was he would prosecute their boyfriends and sleep with the victims. The prosecutor's office knew about this. The lawyers even came to your office, talked to O'Malley, okay, and wanted to give your office this information, and you guys kind of pushed it under the rug. So I'm very familiar with this process, very familiar. What I'm saying is the truth, it's not a lie, because when my lawyer and I, Rufus Sims and I, went through internal affairs to do the investigation, it was 22,000 text messages that was pulled with these different females that this guy was sleeping with, okay? What the internal affairs did to help him out, They only went through 8,000. So if they do a public record request, they're only going to see 8,000. They're not going to see the 22,000. I still have them in my possession. So you're telling them about the Brady violation, that your office wrongfully convict probably 70% of the people that come through your system. Only 300 cases go to trial. And I'm going to tell you this is true too. They can also pull up the Cleveland City Club forum that was done with former attorney Vicki Ward, who's deceased now, and Judge Donnelly, who's a judge down in the Supreme Court. Okay, and also John Russo. They talked about this, and this is public. This is me pulled up, and they can look at. So this is an ongoing thing. I'm working on 5 wrongful convictions right now where there was Brady violation issues, and it's not something that you guys just give over to the attorney. No, you don't. No, you don't. And I'm not saying you. Let's get that correct. But your office participate in this horrible behavior all the time, and you still do it. You still do it to this day. So I would be so glad when you guys get an attorney, okay? You really need an attorney that is fought against this type of stuff, so you can understand what she's saying, because a lot of stuff that she's giving you the information is inaccurate, and I got the proof.
Thank you, Mr. Bickerstaff.
This is not a lie.
Any other questions from commissioners? Mr. Van Leer?
Do you have examples of, like, in your time doing this work with the county prosecutor of cases where there's been, grounds for new trial because of Brady or Giglio issue with an officer, or?
I don't know of a single one with a Giglio issue. Not a single one where a new trial was granted because of potential impeachment material that was not disclosed by the office. That hasn't happened.
So if I do, well, stop right there. I'm not trying to interrupt you, Brian. So if I do a public record request right now, you're going to tell me that you don't have the list of that information, what you just stated to them. You don't have no information on it. You telling me right now that your office do not right now on different judges' dockets have cases that have been filed for a new trial. Right now.
Based on the violations.
Brady and.
Right. What I can tell you is I don't know of a single case out of the 8th District Court of Appeals. I'm head of the appeals unit in my office as well. And so I can tell you that I'm not aware of a single case out of our 8th District Court of Appeals where a conviction was reversed based on the state's failure to disclose potential impeachment evidence under Giglio. That I can tell you.
You mean, are you saying Giglio, or are you talking about Brady issue?
I'm here to speak of the work of the Giglio committee of the office.
All right.
And I don't believe you can find a single case out of the 8th District where a conviction was reversed based on potential impeachment material not being disclosed.
You mean impeachment material for the cop?
Correct.
Was there ever a case that a new trial was given, at least? Is that the same?
We have had due trials granted, yes,
So
for a variety of issues. But as opposed to the Giglio committee that I'm here to speak about, no, we have not experienced that.
Okay, that's great. I did have a few other questions. Is there, just more technical questions, is there a written policy or directive that guides your committee?
We do have a policy. The policy is actually being rewritten. We have done a lot of work in this, and we've learned a lot of things along the way, quite frankly, both in the composition of the committee itself, just internal processes, things like that. So we have governing policy now, and it is actually in the works to be rewritten as well.
So is that a publicly accessible, once it's done, that the public would have access to?
Right, when it's completed, that would be a.
And is there, I've seen some other models for this in other cities. Was there a particular model that you guys followed, or is this from previous?
It was kind of I believe it was sort of a conglomeration of, we went around, asked a lot of questions, talked to folks who were already doing it, asked for, if they had written policies, things like that, that would help inform us as we were developing our own.
So there wasn't a particular policy, like a model that we, just for us, if we, that we might be able to follow.
I know we
too.
could, I know that we relied kind of heavily on some of the, on the West Coast, Seattle, the U.S. Attorney's Office does their own thing as well, trying to manage this information.
And I was just interested because I Googled, Brady Giglio list is Ohio on Google. And there was it just said, here is the definitive public facing Brady Giglio list for Ohio. It was just some other type of nonprofit. However, when I looked up the Cleveland Division of Police, that was not one record for it. So are we saying that there
I
is
am not surprised. I'm not sure what list you might have been looking at, but this is something again it's very related to the actual prosecution of cases at trial. So it's up to the prosecutor's office to determine what they think needs to be turned over in any given case. And reasonable minds can differ on a lot of these issues. Just because my office feels the disclosure is inappropriate, a municipal prosecutor may not. The U.S. attorney may not. Just because the U.S. attorney does not necessarily mean that that my office will view the information in the same way. So no, there's no, you're not going to find a statewide. It may not even be consistent between county and municipality, let alone all the way across.
Right. So I'm not saying that list calls itself definitive, but my concern is that if there's not one, we're seeing that there's not. Obviously, there are officers on your that have Brady violations, right?
That have been identified again. Potential impeachment.
Potential witnesses.
Potential impeachment material.
So
we've identified. Yes.
My concern is that these are people that made it. They're tasked to find this information, and they have not been able to find it to put it on this public database that they've made themselves. So how would we, we might have, what do you think the obstacles are? What is the process for someone to find that information?
To the chair, I just want to kind of point out the time that it's almost 6 o'clock, and I think that that Ms. Sobieski has kind of identified that in terms of how we're going to work with them to get that information. I don't think that is something that she can answer today. I think that's going to have to be something that we decide amongst ourselves about what process we're going to do. And then I'm sure there'll be a discussion that the prosecutor's office has on their own. But I just want to be mindful of the time because we do have a lot of other things to get to.
Yeah, I do understand, but I guess my point is we want to understand what the process is right now for someone to, in order to make this the process a little bit more.
And again, honestly, I think it would be very appropriate to refer you to, your own legal counsel to how to set about, undertaking that task, because it is very different for you than it is for me, who, I have an obligation as a prosecutor and you're coming at this from a different angle, a different perspective. So I think probably, counsel would be the best source for direction there.
Thank you so much. Are there any questions? Thank you so much for your time. Are there any other questions?
One last comment, basically, and I appreciate your willingness to come and let us question you to understand your process. And I think that we're kind of like back where we were to begin with, but I want to reference something you said, Jason. That the information that comes from the prosecutor's office is just one piece of it. So the question I will put on the table for us is who will be the person who will solicit this information from all these various sources to come up with the material or the information that we need to be able to manage according to, this is actually, I said I was going to remember this. This is actually 2.7, but 115.5. Because that's not what she does. We understand now what your office does, but it's only one piece of the puzzle. So we need to find out who, we need to get an attorney because somebody needs to be responsible for gathering this information from different sources to come up with a list that we are charged with managing. Yeah, thank you.
And to the chair, to the commissioner, to the chair, it'll become a turnkey process. So now we know one source. So all you have to do is turn that on. So you say to staff, we want all these letters moving forward. And then it becomes a mandate, and we work with the prosecutor's office to find a way to make that work under the law.
Yes.
So, it's that easy. Once we know the sources, and we already know, we're about to hear from another source. So you're gonna have two sources turned on. The question is, when that data starts coming in, what is your plan and how you do it? So we know one source already determined something. So you have an official lawful ruling, right? So starting simple, that is something that all the commission has to do is say, when we know a letter exists, we will make that letter forward facing on our website. That's one piece of the puzzle where you're meeting your obligation to 115. You don't need an attorney to tell you that. A letter exists. We can get those letters. So all we have to do then is say, it's clear here, we have a mandate to then display that publicly. So that's the simplest part of it, right? At the very simple thing, we already know a process exists. We know where to get that source of information. So now the question is, what do we do with it? Well, it's pretty clear. We have to organize and disclose such information. So it's just a matter of the staff gets the letters. You guys don't have to review them because they've already been reviewed by the prosecutor. And that's the simplest start to meeting your obligation. And we build upward from there. So that would be the floor, right? The floor.
Yeah, that's the floor.
Yes,
If I could, I just again would emphasize the big caveat, which is it's fluid.
Yeah,
These are fluid. A letter that goes out tomorrow regarding one officer could be retracted in a month. It could be retracted in 3 years. It could be never retracted. It is fluid. So that's the only caveat.
Thank you.
Okay, thank you. Thank you for having
so
me.
much.
Yes, nice to meet you.
So now we will hear from another perspective, Mr. Karrie Howard, the Director of Public Safety for the City of Cleveland. Welcome. Thank
Hey,
you.
thank you. How are the day going? I'm doing all right. Can you all hear me? Okay, good. So, with Jason and I, we were talking earlier, and I brought Commander Karrie with me. So, as safety director, I don't deal a whole lot with the Brady Giglio information. I deal with the front end, the disciplinary hearing that comes to the director's level. But I have been a prosecutor at the city level, county level, federal level, and I can tell you that that my practice, and I can't speak for every prosecutor, and I won't do that, and I don't want to speak for the other departments. But when the defense attorney files that discovery list, I don't know if you've ever seen a motion for discovery, but it has standard in that language most defense attorneys use that says, provide me that exculpatory information. And what my practice was that when I received the discovery, I would reach out to the Division of Police and I would ask them for anything in this officer's personnel file that was relevant to that discovery request. For the most part, they wouldn't have anything to return. But every now and then I would get something where there was discipline in the officer's past or something that may be relevant to that request. And then I would hand over what was given to me out of I would put into my discovery response that Officer John Doe, badge number such and such, was disciplined for untruthfulness on such and such date, or disciplined for an OVI on such and such date, and that would be in my discovery response. But we didn't keep a living document, so to speak, with regard to that. In my role as director of the Department of Public Safety, we've done a couple things since I have come on. The decision memos provide significant information behind the reasoning for the discipline that has been given to the officer, so that the officer would be, and anyone reading it would be aware of what the thought process was with the level of discipline that was given. And then the other thing that we had done was the divisional notices were provided much more information, and a lot of that information was duplicative off of the decision memorandum. And that divisional notice would go out to the Division of Police so that they can all read it. I believe you all get a copy of those divisional notices when they come out. And based off of that would go into the officer's personnel file. The Division of Police is working on a policy with regard to Brady Giglio information. Commander Karrie, who is here with me today, I brought him because I figured that he would be able to speak more on point to what you're asking. And not to disrespect the process or to make it minor, but there's, it's for my level as the Chief Executive of Police, Fire, EMS, Animal Care and Control Corrections, Brady Giglio is very important, but it's a bit granular where I have several folks below me, who kind of oversee that. You have the Chief of Police, the Deputy Chiefs, Commander Karrie, and then the officers in the personnel section who kind of, manage the personnel files. So I just wanted to make sure that was clear. That's all. Yeah, sure.
I just had a quick question. So
Yeah.
the discipline decision memos, those are separate than the divisional notices.
Yes.
And are they issued at the same time or separately? Are they always issued?
No. So we issue the charge letter to the officer that gives the officer the date for the disciplinary hearing, right? So if you look at the charge letter and the disciplinary decision memo, they look very similar, right? With the adding of disciplinary conclusion. It has their disciplinary history. It has the conclusions and reasoning. It has the on the tip of my tongue, not just the disposition, but anomalies, aggravating factors, and things of that nature are on the disciplinary decision memo. So the disciplinary decision memo, we have been working in a significant effort to try to have a 30-day turnaround from the day of the disciplinary hearing to the decision. And then once that decision goes out, it's the division has it. It goes out to the member officer, and the disciplinary is executed, and or the officer is acquitted as well, because that happens as well. And then the divisional notice is generated by the division of police, and those divisional notices go out. I'll let Commander Karrie speak to how often those go out, but it's not like we issue a memo. The divisional notice goes out right with it. I think they go out monthly. Perhaps the divisional notices do. So they don't. So you may, if we do disciplinary decisions within the month, but it's after the day after, for example, the divisional notice has gone out, then that discipline won't be on the. It'll be on the mail. Correct. Did that answer your question? Okay.
If an officer is acquitted, and then you request a letter for that officer, is the previous, disciplinary record still all given? Or is it just since that person is acquitted, therefore there's no impeachment evidence?
If an officer is acquitted, right, then he or she would not likely go on have Brady Giglio material related to that discipline in that file, because it would have been, it's like being found not guilty. You don't then apply for a job and then have that go on your background check because you've been charged. So the answer, to the best of my knowledge, would be no. So there wouldn't be anything else because of the acquittal. Does that answer your question?
Well, I guess I'm not saying, obviously I believe when someone's acquitted, they should be free from that charge. But what if there was potentially a pattern that was more subtle of disciplinary conduct, and it never rose to the point of being affirmed as, but that information would never be given to the prosecutors? Mm-hmm. That there was a history.
Well, that's a great question. So that when we make decisions based on discipline, right? We get the officer's disciplinary history. So I can look at that officer's disciplinary history within a 3-year look back and look at the facts that I have in front of me in light of what this officer's conduct has been, to help me decide whether it's more or less likely that the officer has committed this, right? But if the officer is found not guilty of that fact, of that case that's in front of me, then that information would not be a negative mark on that officer. But that previous discipline, if it does exist, that is there. Does that answer your question?
I think so. And then the related question, there have been times I believe that the CPRB would find certain findings, but if the chief of police or you do not agree on their findings, would there be a record? Because if there's a conflict in whether the charge was affirmed, what would you do in that case?
So, and I want to make sure, I'm going to put it in context to make sure that I understand. So the CPRB makes a recommendation. It goes to the chief's level. The chief issues discipline or acquits, and the CPRB disagrees and appeals it to my level. I give it a very good, fresh look, and I may disagree with the chief and find the officer, guilty, or I may find the officer not guilty, or I may, elevate the sanction or lower the sanction. If ultimately, and I hope that this answers your question, if the officer is acquitted at my level, right, regardless of it coming through the CPRB and coming up to the chief, that officer is still considered acquitted, right? So there wouldn't be any negative mark there.
I guess it's just a simple question. If all three entities that are supposed to be watching this are not in full agreement about the charge,
Mhm.
then is there, I would think that maybe if I was a prosecutor, I would at least want to know about it, and maybe
Mhm.
may not exclude the witness, exclude the officer, but there's no record of it. Will there be a record that the CPRB disagreed with the police chief or your,
The proceedings are public record.
right, but would there be in the officer's record? I mean, that's very onerous to go through a CPRB
You know,
hearing.
so I don't know if that would be in the officer's file. But even if it is, and then that request is made for Brady Giglio material, that officer would have been acquitted, and that likely wouldn't have been turned over. Right.
Okay.
Does that answer your question?
I think so,
Okay.
yes. Are there, Ms. Ridgway?
Yes, so to a comment and a question. So one of the reasons, again, that we had requested, both your attendance, had to do with the charter language that basically said that the CPC is to work with your office to establish this policy
Mhm.
for how we do this. And as far as I know, has work begun on a policy with how we are supposed to work together?
So that I don't know. I know that Commander Karrie is working on a policy. He has a draft policy that is getting comments and communications on. I haven't read it fully, so I don't know if that touches on what you're looking for.
Yeah.
But generally, that would be the Division of Police with the Law Department working in conjunction with you all to get that policy drafted, and I would review it. And then if I saw, if I reviewed it and I saw some that I questioned or had my input, then I would contribute my input.
Okay, so the language says, in its first year, the commission's executive director shall work with the Department of Public Safety
Mhm.
to attempt to establish a policy for sharing the following information with the commission in draft format. This is the discipline by the chief of police. With a newly revised GPO is issued, there are about 5 or 6 items here.
Mhm.
So I wanted just to know the status of that policy in terms of working with our
Sure.
staff. And then
So-
the other piece of that
Sure.
is the language also says that we shouldn't have to request through public records information that pertains to these issues. This is information that should automatically be fed to the CPC
Right.
without a formal public records request.
Right.
So I just wanted to make sure that that piece is still valid.
Mhm.
And within a certain amount of time, any decisions toward discipline would automatically be sent
Mhm.
to the CPC.
Okay. So are you not getting the
So-
disciplinary
I
decisions
just
and
have-
divisional notices?
So point of clarification, we get those notices, they're multiple a day. And so you guys haven't been trained on it yet, so to flood you with every discipline letter CPC at this point is in your inbox wouldn't be appropriate yet, but we have every single piece of discipline that comes across.
Okay, you
When
just
we
didn't
get to
know.
the discipline committee, and we establish that, the discipline and accountability committee, it will be one of the first things. We'll talk about what we have, what we know. Ryan is working on analysis of that now. So, and another point of clarification, the language that's in the rules book is the draft language for our rules, right? The law doesn't mandate that we work together, although there's really, what it does say is that we have to do this and we have the power to get that information. So, of course, Director Howard, I believe in good faith, will work with us to have a policy that helps all of us because it is city law and he's responsible for the city charter as well as anyone else here. So we now are mandated to work together to create a list, and his office and those under his charge have this information that we don't have. So it wouldn't be in his interest to not share that information. I would hope that
No.
that he would when we get to it, but we don't know yet. They don't even know what they do with it. So for us to ask, what do you do? They're not there yet. So that's the point of that, right? We have to get involved in that process as quickly as possible. And those conversations, I think, started because I called Commander Karrie before you were all even seated, and I said, this is in our future. Do you have a policy yet? And their response was, no, but we'll get one soon. So when you get seated, we'll have something to go off of. And I think that's what is being
Yeah,
relayed.
and on top of that is that we've made sure, and we added. I don't know if I can't speak to what was done before me, but I can tell you that there's a CC list, and then, on the bottom of the decision memos, that include you all. So to make sure that you get it. So you are in the communication chain. So it's automatic. If an email goes out, it's done.
Thank you.
It's done.
I think the real question was, when we are sitting here trying to review and ultimately approve rules within our organization, and it says that we should have interacted with another department. And I'm very uncomfortable approving anything that involves other departments when we don't know how it feeds into us. Because if there has been no effort to establish a policy, I'm uncomfortable approving that we're going to do this if there has been no effort. And that's why the questions, trying to understand your processes so we'll know what our responsibilities will be as a CPC.
And can I clarify,
Yes.
just to add this too, and I hope that this helps, is that when it says that to work with the Department of Public Safety,
Right.
I instruct the Division of Police to make sure that they are operating on behalf of the Department of Public Safety with you,
Okay.
right? And if there is anything that you need beyond what you're getting from the Division of Police that you want me or my assistant directors to help facilitate, absolutely. We will assist in any way we can to do so.
Thank you.
Absolutely.
Thank
I hope
That happens.
okay.
Hold on.
Ms. Venetia?
I think I agree with you. I think that's there's a little bit of a chicken and egg kind of thing. It's like, how do we create this rules when we don't know what the response is going to be? And then it's also hard to get the response that we need without having the rules to then take to these different departments to say, hey, this is our policy and procedure. We need your support in this. I think that in terms of, I think you bring up a great point about like your comfort in approving these before having that. I think that in creating this draft, because we're creating a draft that will then be sent to the commission. And I think like the last time, we probably will have the law department look it over prior. So that will also be, I think there'll be flagged if anything is truly undoable. I think that the law department will catch that. It also appeared, I think that did we have the Judge Oliver to the chair? Did we have Judge Oliver to the chair to Jason? Did we have Judge Oliver? Because we had someone from the consent decree look over the first set of policies that we read over, correct?
So the rules, you guys have local authority to create your rules, right? That's under the charter, right? So the federal judge isn't going to tell you what rules to create for yourselves. But however, we do have a mandate to create rules in the consent decree. So that means that when we create the rules, it'll go to review to make sure that it's compliant with the consent decree.
Right.
And then if it is, and there's no feedback from the parties about that, it will then go to the judge as proof, filed as a piece of the decree, most likely saying, we have created rules and we're moving step towards compliance.
So then that is another additional layer of review that happened. And then, and I think this is to speak to the point of why we really do need to get a lawyer contracted to do it. Then we could also have a lawyer look at it. So I think that I think that it is okay for us to move forward with creating this kind of draft policy. And then, because we have, I think, that kind of review that'll be happening that can also help identify if there is something truly undoable that we are trying to put in here, that depending on what the other parties are going to do.
Okay. Ms. Bickerstaff, you had a comment?
Yeah, I had a question for Mr. Howard. Okay, so I'm familiar with the process of when officers go before you in the investigation. So this is my point. So if an officer is accused of, let's say he's accused of falsification on a report, but then he went before you and they said, oh, he's found not guilty, but the court said, well, it doesn't matter that he was found not guilty with his department. He's guilty. On the criminal matter, he's guilty.
So
So you say after so many years that this information is no longer in their file. But if they have, let's say he's been acquitted 2 or 3 times, but he falsified reports 2 or 3 times, that's a pattern. That's a pattern. Let's say it only went criminal one time, but then you have other information in the file to show he's done this before, but he was acquitted through your office. Because remember, standards are different in your department than it is in criminal matters.
Sure.
The
Sure.
standards are very different.
Sure.
So just because he might be acquitted by you on being untruthful, he could be found guilty through the court.
Of course.
And I know that to be true.
Sure. If I can address that briefly, and I'll make sure that I'm brief. So generally, what we try to do is we try to make sure that the administrative disciplinary process happens after the criminal process. However, if the criminal process is taking too long, and I've only done this, I think, once or twice, where I have had the administrative hearing ahead of the criminal disposition of the case. Now, whether or not an officer gets, if an officer is acquitted in criminal court, I'm very adamant, and this is what my reputation is, and my practice is that just because you are acquitted in the court that has a standard of beyond a reasonable doubt does not mean that you will be acquitted in the administrative action, which has a lower burden of proof. Okay, so I'll just, as an example, say an officer gets cited for a DUI, right? Say that they get acquitted of the DUI and they come in front of me. It's not an automatic not guilty. I am going to look at, with the lower burden of proof that I have, I'm going to look at the body cam footage. I'm going to look at the body cam footage if it's an outside jurisdiction. I'm going to read the reports. I'm going to look at the facts and circumstances, and I will still find an officer guilty of an OVI. Say an officer goes to criminal court and they plead from an OVI to, say, physical control or reckless operation, which is common textbook practice sometimes for first OVIs. Okay, then just because that it was reduced there doesn't mean I'm not going to review it for an OVI, right? I may take that into consideration, but I will still, if it's there, be able to find you guilty under the lower burden of proof to find you guilty of an OVI. I sum all that up in this, is that what happens in criminal court is not determinative what happens in my administrative hearings. That's period.
Okay, thank you. I had a question. So when you say lower burden, could you maybe substantiate that a little bit more in the context just for laymen?
Sure. So there's beyond a reasonable doubt, right? Which is criminal matters. There's by preponderance of the evidence, and it's clear and convincing, right? So for the administrative hearing, generally use a standard of by preponderance of the evidence.
So similar to like a civil burden.
Civil burden,
Yeah.
yes.
Okay. And could you just, because we do want, to understand the impact, not just on the community, but
Sure.
the officer, when the officer has a Brady Giglio letter from the prosecutor, what do you do to their responsibilities? What role do they play in the division after that point? Are they demoted? Are they changed? Obviously it depends on, but I think if it rises to the occasion of a Brady Giglio letter, what impact does it have on their basically career and their responsibilities?
So what happens is that if I discipline an officer for untruthfulness, there's a presumption of termination. I can probably count on one hand where an officer was charged with untruthfulness and they've been retained. But that doesn't say they don't go to arbitration, the ones who get terminated, and they get their jobs back. When they come back, when the arbitrator says that this officer is to be reinstated and to place back into the role that they were in before, they go back to the role that they were in before, right? So if an officer is on a Brady or Giglio list, that doesn't give them a desk job, okay? But we run into the complication of whether or not this officer who has now perhaps gotten their job back can be leads certified, right? That's the complication that we have. So if the officer cannot be lead certified, that means that they cannot be around the computers that carry this pertinent information. So we have a lot of difficulty in where to put these officers. They may go to the horse stables, they may go to the gym, but we have to comply with the arbitrator's decisions, right? Now, if the officer is continues to be a patrol officer, continues to be a detective, and they're on the Brady Giglio list, then that is up to the prosecutor as to what they do with that officer, depending on what the facts and circumstances are. As a prosecutor, my responsibility is to decide whether or not I can proceed on with this case or not with this officer underneath these Brady Giglio conditions, or if I can go to trial and rehabilitate the officer on the stand to the jury. But that's all on a case by case basis. Does that answer your question?
I think so. I guess, so it's interesting that, so what are you said presumption termination for untruthfulness. So any Brady or Giglio violation would rise to that point of potential termination?
So when I look at it, I don't look at it as in a Brady or Giglio sense, right?
But I'm just like the behavior.
I just look at, was the officer untruthful, and to some extent, like to what degree and what about, right? There's a difference, because it's when officers when they write reports, they may forget. It's a perspective, as what you said. But an officer files charges, fraudulent charges, or if an officer fills out a fraudulent time card, you have to look at, there's degrees to everything. How impactful is it? And you'll get, depending on who you talk to, some will say, it's not for you to look at what degree it is. But I'd like to give the officers who come in for disciplinary hearings the full due process and look at all the facts and circumstances and make decisions off of the totality of the circumstances.
Right, so my point was only that the integrity of the officer is very important.
Oh, the integrity of the officer is absolutely important.
Right.
And I say that from having been a prosecutor. I've even done defense work. And then even in this role, the citizens of Cleveland deserve an officer, an integrity officer. Absolutely.
Ms. Benito?
When you have law enforcement officers that come from other divisions and other jurisdictions that apply then to be an officer with the Cleveland Division of Police, is there ever any conversation with the prosecutor's office in the other jurisdictions to ask if there were any, if they had, I can understand that there's not so much a formal list that all prosecutors' offices are keeping that they would think of like a list, but is that ever anything that gets asked about in addition to their personnel file from the other departments?
So as you heard today, the prosecutors get Brady Giglio material. If it's not there, they don't. It says it's not there, right? We don't talk with the other prosecutor's office, but we do talk with the other jurisdictions where they come from. And what we get through our personnel background check is what they've been charged with, what they've been acquitted of. They could say, they were charged with reckless operation but found not guilty. So we get beyond the Brady Giglio, and we have to trust the information that we're getting, right? And as the prosecutor's office is to trust the information that they get from the police department, the division of police. So when we are looking, if someone applies from a different jurisdiction, we get what their personal file looks like. I'll go just a step further, is that if an officer leaves the division of police and they apply to come back and we see things that are discovered, they can't come back either. We've had that happen.
Commissioner Van Leer?
The chair. So this is sort of a question for Jason, and apologies if it's already been answered in a different way, but so you've already sort of automated this discipline. You're getting all the discipline records. I mean, how hard is it to automate this Giglio Brady piece too? Is it already included in there? We have to pull it out, or is it much more complicated?
Through the chair of the commissioner, it's much more complicated. So, and getting the discipline data was quite frankly complicated. We had to have a federal judge order that wasn't willingly given to us. Although the Bibb administration, we haven't had a test of what they are willing to share. Data 115 didn't exist at the time, but that was a hard fought to get on that list. So just want to make that clear. The other commission had 2 years of a battle to have automated access to things. So I'm hoping that Director Howard will, we can sit down and look at automation of other information that will help flow so we don't run into those conflicts. But
Can I add a point of clarification there just real quick? Is that That wasn't me.
Yeah, yeah.
Okay,
Yeah.
so the adding of folks to that list of people who received it was, hey, I didn't get it. Oh, well, I just.
And I didn't mean to imply that he was involved in that. But that was a long fought battle to get that information automated. So to the next point, automating Brady Giglio starts with knowing what they do with it. So the question that I posed to the department before we proceeded was, when you get that letter, and Commander Karrie could probably speak on this more now where they're at versus months ago when I asked, what do you do with it? And the answer was, well, we take that letter and we put it in the individual officer's file, right? So there was no tracking of where those letters are. So the only way we would be able to find those letters is to look into every file and say, is there a letter here? Because it seemed like to me from the conversations I had with multiple people there, that it's on the officer then to, carry that around and tell people, hey, I have one of these letters, right? So there's a lot to be desired in this process. That's why I encouraged us in the rules to work with them to come up with the best process so that we can automate it, right? And there may be disagreement between what you guys view as an integrity violation that warrants being on the list that 115 mandates you to create versus what Director Howard is. And that's thinks is an integrity violation that internally he would consider a Brady Giglio, right? But you guys have a charter that now says, hey, you may have a difference of opinion. So what happens there is untested, right? But there is something to say where he creates a DN, right? And you guys can sit in a room with Director Howard and say, well, we think this is Brady Giglio, and have an argument about it or agreement on it. And that's untested. We don't know what happens then, right? But what we do know is letters come, they go in files. So the question is, how do we get those to start? And then how do we, moving forward, agree that when a letter comes, what is the process so that we know where those letters are now that we're mandated to build a list? How do we access that? And then what are the general parameters that both the commission and the division agrees would mandate an officer's behavior through internal discipline? Like Director Howard said, well, what if they weren't found criminally guilty, but we're all in agreement, both the commission and Director Howard, that this is an integrity issue, right? And so we may say, hey, Director Howard, we think this person should be on the list. What do you think? You say, absolutely, right? Because this is a new thing. It didn't exist before. So that's where we're at now, is there isn't a system. That's why I encourage us to put a timeline in the rules, say we're going to do our due diligence to work with Director Howard and the Division of Police to have a system in place within 180 days, with the caveat that we know these letters are coming, and in the meantime, we can at least get these letters out in public. So that's kind of what I was thinking when I authored these rules, is it's a two-step process. Very first is, let's intercept letters, right? Let's start a process for finding letters that already exist, and let's develop a policy jointly with the division and with Director Howard on how we're going to address this whole thing in 115 and see where we agree. So did I answer? Okay.
Thank you, Mr. Good. I want to invite Commander Karrie, would you like to come in and provide some perspective?
Do you want us to move to swap?
Yeah, if you can continue in dialogue with folks who want to be there. Thank you. So, Commander Karrie, could you just tell us what your perspective on this and where the process is at this point?
Sure. Good evening. I'm Commander Brian Karrie. I'm Cleveland Division of Police. I've been assigned to the Office of the Chief for approximately 12 years. So I've been working with Jason here for several years now. Jason and I worked very diligently on the new disciplinary guidance policy. And just update you with that. And the process is long and difficult. Jason and I remain in contact as far as the status, and there's various stakeholders, you all as well, in the Department of Justice and monitoring team. So there's a series of reviews, and we're still in that review process of going back and forth with the Department of Justice and monitoring team and fine tuning that policy. Chief Director Howard has been involved with the process as well, and it also incorporates 115. So there's a lot of pertinent articles that I'm sure you're aware with that affect the disciplinary process itself. So I think you all will be very happy and pleased with the policy. So trying to get that finalized, and Jason's been a big part of that. and helping that, if they had some recommendations early on, and Jason and I worked hand in hand getting that policy together. As far as the disciplinary process, I think that the discipline and Brady Giglio, they interact. They're not completely separate. And just listen to you all talk. I mean, I've been doing this for a while now, and I think even with the former safety director, I can recall cases where the safety director dismissed the case, the administrative violations, and there was no criminal violations. But you may have the county prosecutor that they're not bound by collective bargaining agreements and timeliness issues. So just because the safety director had to dismiss a case because of maybe some timeliness issues in the collective bargaining agreement, doesn't stop the county prosecutor from an impeachment letter. So they are different. You have the disciplinary process, and then you have the county process. So currently the process, as Jason mentioned before, I'm sure he doesn't want to flood you with all this information because it is daily. These letters go out by the hundreds annually. So there's a lot of disciplinary hearings, due process hearings, which officers are entitled to receive their due process. So Jason gets a copy of those along with the disciplinary divisional notices. So the disciplinary divisional notices, those go out. We try and get them out monthly. And they vary from 2 to 3 pages to 15 pages or more. The Chief Director Howard has expanded that notice, as he explained previously, about the rationale, the aggravating, mitigating factors. And I think it's just a matter of being more transparent with the officers and also the public. So, and those letters are all on the our GovQA website, can be accessed there every month, and redacted with officer names, but the officers' names are included in divisional notices. So with that being said, the process with the county prosecutor's office, I oversee the case preparation unit, the policy unit, the inspection unit, and our Office of Compliance, which works with the Department of Justice and our monitoring team. So we provide the county prosecutor's office with every month with the divisional notices, which explains the discipline. So the county prosecutor's office may require further information, and we cooperate with them because they're our partners. And I also receive requests from the U.S. Attorney's Office, same information, and we'll also be working with our Cleveland Municipal Prosecutor's Office. So we have Internal Affairs Superintendent Chris Violin. Chris and I have been working on a draft general police order, which is called a disclosure of exculpatory evidence. And those processes, so it's in its infancy form. We've had 1 or 2 exchanges with our stakeholders, and like I explained, it's a process. I really wish the process was faster. But I mean, we've been under this consent decree now for going on our 8th year. So these policies, they take a while, because you have individual monitoring team members, individual Department of Justice members, division members, a lot of stakeholders involved that want to comment on these policies. So there's quite a bit of back and forth, and it just takes some time. So, but I'm certain the division has every intention on sharing this draft with you all before it's filed in court to comment on. So, we intend on fully cooperating with the commission and look forward to working with you all. So, whatever I could do to help facilitate that process.
Commissioner Benito?
Thank you so much, Commander Karrie, for being here. So Jason had said before that the most recent answer he had about what happens to the Brady letters that come to you guys are going into the personnel files. Is that still accurate, or are they being compiled in a separate file as well?
Yes, so it is, to the best of my knowledge, that they are in the personnel file. But the personnel unit is not under my command, but I do know what the county's information was, that they provided those letters to the office of the chief and the officer, and that's is accurate. As far as where those are stored, I would assume that you were right, in the officer's personnel file.
Follow-up question. So I guess one thing that I am kind of thinking from a operation standpoint is if I were in the division and you know, we are getting these Brady Giglio letters, and to me it would feel important to know, okay, and we haven't gotten the full scope yet of how many people are on this list. I mean, so this could be totally irrelevant, but if everyone of, you know, if maybe 50% of my officers in a particular district, you know, or even like in a particular division of it, or like smaller subset of the district, were on the Brady Giglio list, from an operations standpoint, I would find that problematic, because then if a case is, you know, then there's a high percentage of, if a case goes, you know, goes to court, then there's a 50% chance that if a crime occurs in that district, that could be a problem for the prosecution. So I guess I'm kind of curious. I understand why it would be included in the personnel file, but I guess from an operations standpoint, I'm kind of curious, wouldn't that be important information for you guys to be thinking about, you know, how many of our officers are, you know, have been flagged as, you know, maybe needing to be considered in this disclosure? Where are those officers concentrated? Are they mostly beat officers or detectives? Like, so I guess I'm kind of curious why, just kind of going into I know I understand that might not be in your command at all, but that's just kind of where my mind goes.
Sure, I understand what you're saying, and I agree with you. You know, I don't think. Well, first, let me make this clear that the division does not have a list of officers. So just so that's clear, I will say that it's case by case. You know, because not every case is the same, right? So you have to look at those officers individually and their acts. You know, and the acts of misconduct, and if it's criminal. And as Chief Director Howard has said, you know, the serious violations, you know, those officers, you know, it's been in our policy since 2018 or 2019, excuse me, regarding untruthfulness, false statements, you know, bias is in there now. Jason and I incorporated that into a group 4 violation, which is termination. So a lot of this that we're discussing here today is incorporated into our newly revised disciplinary guidance policy. So they go hand in hand together. So a lot of times, you know, not every time, but these things can work themselves out. You know, if the officer resigns, if they're convicted of some type of crime, there's a possibility that they will be terminated. And then we also have to consider if the officer receives their job back, you know, through an arbitration process. You know, if those officers need to be reassigned to some type of special detail assignments where they maybe don't have contact, you know, or they're taking reports. It's a case by case. I can't give a general, you know, answer that, you know, everybody's going to be assigned to a mounted unit or anything like that. I mean, it really is case by case, but it's not those types of officers, I think, are few and far between.
Thank you.
So I just, and I'm probably going to end up telling this personal story over and over again. So it's interesting that you mentioned bias was a group 4 violation. So I went actually through an OPS and CPRB investigation, And the two other charges were affirmed by the CPRB, but on the issue of bias, which was fairly obvious to my investigator and to me.
They recommended a group 2, right?
No, they split 3-4 on the vote.
Okay.
So what I'm interested in is obviously that didn't get even to the Calvin Williams. What do we do in these cases where, and I'm not really sure they even understood, I guess, maybe our reasoning for it. Where does like nuance come in for something like that? You know,
Sure.
and I didn't know if it was a group 4-2 violation they were
Okay.
seeking, you know, and my intent was not to have, right, like the officers fired, but it was to me a very biased situation.
Sure. So I'm not familiar with the case you're talking about. I don't know if that particular case was sent to the office of the chief. Do you know if it was a sustained violation?
It was the same violation for the two other, failure to make a report and unprofessional conduct, and bias was a split vote on the CPRB. I think there were
Okay,
7.
so that was not sustained.
Right, that was not sustained.
Right.
So
So the chief under the charter, you know, when he'll receive what's we call our findings letters from the Civilian Police Review Board, and the division will proceed with the sustained findings. So, you know, we don't attend the CPRB meetings. I don't watch them. You know, I only focus on what the CPRB sustained. So I'm not familiar with that case. I do know there was an area of concern of the CPRB only recommending, you know, not a terminable offense for a bias, which was a concern because, you know, we're still trying to implement these policies and that policy is not effective yet. So I don't know if that answers your question.
Well, if I may, so just so everyone's on the same page, because so there was a work group formed in 2019 under Richard Jackson, who you've all met, a past commissioner. We brought in people from all over the city, HR professionals, labor law attorneys. We had officers from the labor unions in this work group. And the purpose was to look at the disciplinary matrix and the disciplinary policy. Now, our problem was there was an updated version that just happened in 2019. So we were out of cycle when we did this. But we did some of the best work this commission has ever done. And when he's talking about a new generation of the discipline policy and matrix coming out, that isn't effective yet. So even the idea of group 4 started on this commission, and the idea was to expand termination offenses, right? Because the problem we were seeing from the community was there's too much discretion, and Director Howard's predecessor was a whole report was written about the possible abuse of that discretion, right? Because it's too subjective. So what we looked at in our committee was, okay, we need to take away the ability of a safety director being able to apply a massive suspension to what the public wants to be a termination, right? So we proposed a group 4, expanding it, which is a new group, and that's presumption of termination if you're in that group, period. So you're either getting terminated or you're getting it reduced to a group 3, but you are not getting a suspension for what could be what everyone agrees at this point should be a termination offense. And I haven't seen the updated draft, but it's my understanding it has made it through. And we did that in probably early 2020 was the delivery of that. So for 3 years, it's been deliberated over there. And that's how long it takes sometimes to get a new policy in this consent decree process. But it sounds like we've made some headway, and a lot of the CPC recommendations will be seen in the next iteration of this draft. And I don't ask you to comment because we don't know for sure yet until it goes to the court and it gets approved. It's not an official thing, but that would be an example of some work that came from here, the idea of a group 4. So I just want to clarify that doesn't exist yet. It doesn't. But untruthfulness happened in 2019. That was a monitoring team recommendation that was later accepted by the court, that the presumption of termination if you're untruthful, that came from the consent decree. That never existed on the department before. And that has been, since you've been in your position, I think that has been the standard, right? Or did it change? Yeah.
All I know is that standard.
Yeah. So when you came on, it was there. But his predecessor for untruthfulness could give a suspension. So that was one of the problems why we have the consent decree, right? So
right.
Yeah, Jason's correct. And these group 4 violations, just to be clear, this was a CPC recommendation, and we're talking about the most serious violations, felonies, escalating misdemeanors, the most serious charges. But the CPC, the committee also, in fairness to the officers, the goal is we also want to empower our frontline supervisors there at the district level for these minor offenses that they could be handled maybe with non-disciplinary action or coaching. So the chief of police and chief safety director, we're not sending every single minor misconduct to him where he's just having hearings every single day, because it's just not practical, right? So the new policy, I think, is more efficient as well, where these low-level offenses, maybe they can be handled with non-disciplinary type action or retraining, for certain low-level minor offenses. So I think that's also, a good part of the policy. But as Jason said, it is a draft, and we're incorporating all of 115 as required by law.
And just to add one more thing before we're back over. I think in the ideal world, when we get the right policy, right, I don't think you'll see as much of a gap between a Brady Giglio list and officers who are still in the department. What we're trying to do is close that gap, right? So the idea of, the preponderance of evidence, right? If Director Howard wants to remove someone and is successful in that, right, and it's for something that would also put that officer on the Brady Giglio list, it's not an issue anymore, because now he has the tools to terminate that officer, right? Whereas before, you have this massive gap, right, where officers are committing things and they're still coming in and working, and it didn't make sense because you're on a list, right, and you're potentially blacklisted. And why should you be an officer at that point? What value do you have? So you end up at the horse stables or the gym, but we're paying an enormous salary for you to carry a badge and hold a position, right? So we're trying to close that gap between the discipline policy and this list, and hopefully the director and the staff over there will have more tools to be able to remove officers that would have fallen in this gap before, where they're on some list, but they're really not effective as officers anymore. And what they did probably was something that was such an integrity issue anyway, that I really don't believe that the public or even the city in a lot of these instances wants them there. So, that's ultimately, I think, where we're trying to head, right, is to close that gap.
Mr. Donaldson?
Just for clarification, for me, so the disclosure of evidence policy that you mentioned and the discipline policy, there's two different things that are the same.
Correct. No, separate.
Okay. And then the disclosure of evidence policy, how long has that been under draft or?
Just only a few months now.
Okay.
So Superintendent Violence started that draft. I believe the monitoring team, had advised us or recommended that we start this draft policy. We knew it was going to also be, required under 115. So, we're just trying to get ahead and get that started, because, as Jason said, some of these policies take years, right? So, we fully anticipate, cooperating the CPC and sharing that document, but it's still in its infancy stage, and doing some commenting back and forth with the Department of Justice.
And I do want to give credit to Christopher Valon, superintendent, because he was the last person I had a conversation with, and he made a commitment on the phone with me to begin a draft. And so now it appears that he kept his word, so that's big, because he said, we'll work on this proactively before the commission gets here and even bring it to the monitor team. So I want to give him credit for that, because Commander Karrie said, talk to him. I mean, I had the first conversation with Commander Karrie. He's like,
That's right.
Talk to Christopher Valon. And Chris made a commitment, and it appears he kept it. So to give him credit for that, working ahead.
Yeah, he's done a great job, and we received our first round of comments from the monitoring team and Department of Justice. I just responded to those comments today, actually. So Dr. Anderson, who I don't know if you all met, so we plan on sending that back to our stakeholders tomorrow. So move things along.
Just a clarification to the chair and to yes. When our mayor went before Judge Oliver, trying to determine if we could exit the consent decree based on that 47% supposedly progress that we have made. Did that 47% include policies and different things that are in progress? Because the judge responded that that 47% was not actually in effect yet. So was he referring to some of these policies that are in draft form now are still up for review?
I couldn't answer. I wasn't.
You were.
So I can't speak for what the judge was referring to, but I could tell you that the number again comes from the CPC, right? So that is not a number that the court uses. That's our quantification of their system in here that has a very complex rating. So we put a number on these and so you'll hear it in the community a lot because that's what we wanted. We wanted a more linear, measurable number to this thing. So that is a number that is disputed by the parties, just to be clear, but to your point, work is always going on. It says it in here, you'll hear the city say it. There's never a moment where someone isn't working on the consent decree and moving forward policy. And these reports that are given to the judge are often a little bit behind of where we actually are in the process. But this policy here is responsive to 115. So this new policy wouldn't have been created if it wasn't for 115. It's an extra thing. It's not mandated by the consent decree to do this exculpatory evidence policy, but it is now 115 is being incorporated into the operation. So it's a proactive thing. So it's going to be a bonus. And yes, because it deals with discipline and it deals in that realm and it deals with us, it is part of the consent decree because for all those reasons, but it was not mandated in the original consent decree. It's because of 115 that it is now being created.
Thank you. I just had, a few more comments. Now that bias is one of these things that we've elevated to group 4 violation, that seems to be on the list, maybe the most nebulous for people to understand and as I experience. So I'm just hoping that for the sake of the understanding of the officers too in the community, that there would be more education about what that means, especially for communities that it may not be obvious to everybody in Cleveland that there is bias, right? Or the nuances of those interactions.
So I can tell you that when we talk about biases and prejudices, one thing that we know is that we all have some degree, right? And it has to be that manageable kind of degree. And you have some officers who, as people, and I would imagine that are acting without an awareness that they're being offensive. And that's why we have to also be proactive with providing opportunities for training. That's why, within public safety, I changed one of the assistant director's positions to be not just the assistant director of administration, but also diversity and inclusion, right? So that we are leaning forward and looking at educating our officers on the cultural differences. Because some officers, they may not interact with people of color in their communities, right? So they may not know how to respond to a mom or a dad who is coming out, wondering, wanting to have a conversation, but they come across as aggressive, but maybe it's just passionate, right? So that we have to do a better job of leaning forward with that education and training.
So could you explain what that looks like in the training? Because I remember once I got a ticket in Tremont and I was labeled under my race with the letter O that was handwritten.
Mm-hmm.
I had no idea what it meant until I went into my record and it said the word Oriental. I thought it meant other, which was, being far East Asian, it's pretty clear where my country origin. But then I looked up some of the other officers using kind of East Asian last names, and I was surprised that some of those officers labeled these East Asian citizens as Caucasian because they didn't even realize what Caucasian, the Caucasus Mountains, it's not, that they thought that it meant Asian. And so I feel that expresses both with the use of the Oriental and the misnomer, a real, like, this was, I think, like maybe in 2014 or something around the consent decree, a real opportunity for us to just bridge those gaps. And then I dig a little, sorry, we're almost there. Dig a little deeper, and I think there were South Asians that were labeled Black Africans. To me, I don't know what the result of those things are, right? If when you observe somebody, but could you explain? And we only have a few minutes left, but just the type of, like, tell us what does the bias education look like?
So, what I'll do is I'll start off and I'll pass to Commander Karrie, who will probably go into, but there is bias-free policing, right? And that bias-free policing is really intended to make sure that folks set aside assumptions, right? Because assumptions is kind of where that goes into. And there's a generation of folks who grew up referring to Asian people as Oriental, and they don't understand that is offensive, right? There's a generation of folks who grew up and referred to people of color as Negro, right? I mean, that was still in my adulthood. I recall seeing under race Negro a box to check, right? So that bias-free policing is not just getting rid of assumptions, but it's also addressing a transformative world, right? That's separated by age demographics as well, right? So I'll let Commander Karrie speak more on the bias-free policing training.
Sure. So we have, the division has a court-approved bias-free policing policy and has had one for several years now, working with our Department of Justice partners and the monitoring team, as well as the CPC. That policy has been effective for a long time. So the officers are also being trained on it annually. And I'll give kudos to Commander Magooth, and he just received accolades from the department or the monitoring team as well in the latest semi-annual report for his efforts and his training, because it is continuous. It's not just a one and done training. Because officers exit and we receive new officers. I can't speak for Commander Magooth, but I could assume that it'd be safe to say that the bias-free training is offered to the new recruits as well. But as far as it may be, don't quote me on this, but it may be in session 2 or session 3 for this year. But from what I recall, it will be incorporated in this annual training as well. But I would defer to Commander Magooth and his training section. They've been doing an excellent job of training our officers, whether it's through LMS and our target solution software or at the annual training that we do for the bias-free. But the training section does an outstanding job with that for our officers.
Thank you. So we're almost out of time, but I forgot a question I wanted to ask if we can take. We have 180 days, or that's our goal.
It's a random number. It could be, that's just a fair, practical number.
Whatever it is, what would you? Thank you for so much for your willingness to work with us on this. What would you envision our next steps be together?
Well, I've worked with Jason, in the past already, so I would like to. We have an excellent professional working relationship together. So I'm there every day in the chief's office. So whatever you all need from me, I'll be transparent. And if there's things that I cannot provide because they're just maybe in a draft form and they're not ready to be disclosed yet, I'll be honest and upfront with you all, and look forward to having a working relationship with you all as well.
Thank you.
Thank you.
Thank you.
Thanks.
Thank you.
Mr. Howard, do you have anything to say for?
No, I just thank you all for the work that you do, the time and commitment that you put in. We share the goal of having a very constitutional, compassionate, police division of police. And this is a way to get there. And if you have any questions, please feel free to call me. I'm available. And if you get my voicemail, I will call you back. Okay. But thank you so much.
Thank you so much. Thank you to all of our guests and all of our listeners. So we are now at the end of our, not our intended agenda, but certainly this is a good stopping point for us to take in all this information and think more. Would anybody like to make a motion to adjourn the meeting now?
I just wanted to,
Did I adjourn?
I wanted to double check when our next meeting is.
Oh, yeah, we do need
Thursday the
to,
6th. Our next meeting is Thursday, the 6th. Do we want to schedule the one for after that?
is it Thursday the 6th? Okay, it is, yeah.
I have it as Thursday the 6th from 5 to 7.
We had scheduled that.
Yeah.
Do you think that's enough?
We had already scheduled it.
And on the 12th, we're having the full commission. We will be having our election, hopefully. And so that will be a full, so I don't see any reason we have to meet before the 12th again. Where would you like the 17th? Should we get back on that day? That's the third Monday, so I can't do that unless we meet earlier.
I would, for future meetings, it would be helpful for me to not meet on Monday to have another obligation.
Thank you.
Thank you very much, appreciate it.
Thank you.
So on,
So you're saying we don't have to do the 5th, we don't have to do April 6th?
we are gonna do April 6th. Do we want to schedule it on April 6th or do we want to schedule it now?
I think it would be helpful to schedule a couple meetings out, that way then it's in the calendar.
So you can't do Monday, I can't do the 17th anyways, so.
I'm sorry, I was replying to the email. I'm not looking at the date
Okay.
right now.
Oh, yes, I did.
Well, she can't do the 17th, so, what day that week is good for you?
I can do any other day in April. I mean, that week,
So I
yeah.
can't do the 18th,
Mm-hmm.
well, the 19th. Well, it was switched, that's our whole commission meeting, so we can't do the 19th.
The
No.
full commission is the 26th.
But I think the training committee might have something on.
Nothing is scheduled into April except for the 12th, the 26th, and the 6th.
Okay.
There's nothing, scheduled.
Yeah, I can do any other day that
That was
week.
April 6th.
The
Yes,
6th
our
is
It's
this
our
meeting.
meeting.
This meeting,
Oh,
okay.
okay.
Training,
I didn't put that in.
training,
And
training.
then the 12th is the full commission.
Uh-huh.
Correct.
And then what's the other one you mentioned?
The 26th
26th,
again is
another
the
full commission.
Okay.
And the 22nd, we have a training, correct?
All day
Jan said
training.
April 22nd, correct. It's
I
all
mean, I
day.
really do, because this is gonna make a big difference.
So we could do the 19th, the 20th, the 21st.
The city, you know, depending on this,
Quarterly meetings, 18th.
because it just
Yeah,
won't.
It's the 21st.
When I get in
Yeah,
trouble.
that's a Friday.
I don't
Friday.
Yeah, that's
Yes, yeah. I was just naming days. We could do the 19th or the 20th.
The 19th or 20th?
Yeah.
I would prefer the 20th.
20th,
Okay.
that works for me.
That's Thursday, the 20th.
And you'll send out a
Yeah, I'll send it.
Thursday, the 20th, 5 to 7 also?
Okay. Thank you.
Thank you.
And you guys gotta listen to the public, especially to people that's in the profession and know what's going on.
All
Okay,
right, are we adjourned? Or you wanna-
we are adjourned.
Great.
I thought we were already voting.
Okay, thank you, everybody.
I don't wanna meet every day of the week. And I wanna
Sure.
meet Friday.
Well, I don't wanna meet every week either, you know, we can have.
Well, we were
I
gonna-
thought we were
Brian,
gonna
you can
meet
end
every week until.
No, we
No, I
were.
mean, have a meeting, there could be a meeting.
Oh, okay.
Oh, okay.